Welcome to LawPath's legal education videos. My name is Damin Murdock. I've been a lawyer for more than 10 years. Today we're talking about constructive dismissal. You may or may not have heard of it, but I'll explain what it is today. Now, you've probably heard of an unfair dismissal. An unfair dismissal occurs where an employee has been terminated, and that termination is harsh, unjust, or unreasonable. So you'll often hear where someone has showed up late for work and they're terminated. That's harsh, unjust, unreasonable. Now, if they've received 15 different warnings in writing about showing up late and they didn't continue to do it, maybe that's justified. But at the end of the day, an unfair dismissal is a termination at the initiative of the employer. And what we're focusing here on today is at the initiative of the employer, or the employer's initiative. And that's what's key about constructive dismissal. And it's key about constructive dismissal because there are circumstances where someone resigns because their workplace was so intolerable they had no other choice. And that is the definition of constructive dismissal. That is that your job has been so intolerable that you have had no other choice but to resign. Now, if you try to imagine how to prove to a judge that your workplace is so intolerable that you've had no choice but to resign, you can imagine that that's a very high threshold. And so most of the time, if you are being bullied or you feel that you have no choice to resign because of the way you've been treated at work, then in those circumstances, I highly recommend you talk to a lawyer, because you might fall into the realm of constructive dismissal, but constructive dismissal is very difficult to prove because you have to show that intolerable element. And so what normally will happen is that if a situation has occurred in your workplace, you can't not work there anymore, you would normally write to your HR manager and you would say, I'm writing to you because the current workplace is so intolerable because of X, Y, and Z. And the only way I can see myself continuing to work in this business is if you were to address X, Y, and Z. And put me into a position which is safe, so that I feel safe at work, but I am ready, willing, and able to continue to perform my duties as long as I'm in a safe workplace. And so what you've just done is you've given the employer an ultimatum, you've explained what your issues are, you explained you still want to work there, but you cannot work there under the current situation. It's then up to the employer to prove that they have addressed those issues, if they are real issues, and dealt with them. And if they do not deal with those issues, and because of that your workplace is so intolerable, then you can resign under protest, and that is still considered a termination at the employer's initiative because they are the one that initiated the termination by treating you that way. Now, I've never heard of an employee winning a constructive dismissal case without legal representation. Because the case law is so strict, because the area of law is so strict, and because primarily it's based around common law cases, looking at the factual circumstances, looking at your specific circumstance, and determining whether that is actually a constructive dismissal and did you do anything about it before you resigned. A lot of people will resign in the heat of the moment. That is not going to be a constructive dismissal. But let's get into that for a second. Now, examples of constructive dismissal include when an employer has randomly reduced your salary, they've changed the nature and the scope of your work, so they've downgraded you to a lower role. And the reason why those two incidents are considered a constructive dismissal is because your employment contract says you get X. By you now getting paid Y, they've changed the terms and conditions of your employment. Changing the terms and conditions of your employment That is so intolerable that you do not need to accept that, and you can resign from your role if they don't agree to put your salary back up to how it was, or demoting you without talking to you about it or without any justification. And then you get into the bullying and harassment. At the end of the day, I don't recommend you ever to resign if you think you're in a situation of constructive dismissal unless you first talk to a lawyer. But that is an area of law, and there are circumstances where you can resign and still sue the employer for unfair dismissal. If you enjoyed this video, please make sure you subscribe to our YouTube channel and give us a thumbs up. If you have any questions, visit www.lawpath.com.au. Thank you very much, and I'll see you next time.